Good morning, Ethasham sir, and I formally once again welcome you.
Assalamualaikum, sir.
Wa alaikum assalam. How are you, Mr. Sultan?
Yes, Alhamdulillah, fine. How are you, sir?
I'm fine.
Sir, actually, I wanted to make you a phone call, but I think you are busy. That's why I didn't make you a phone call.
Yeah, today you can make.
Okay, sir.
In
What
the,
time it will be?
it should be around between 4 and 5.
Okay, okay. Thank you, sir.
You're welcome.
Sir, can I discuss?
What?
Uh, it's like it's not a our relevance issue of the topic, but it's like some refugees are getting migrated in Bangladesh to the Pasanchor, the
Hmm.
particular cyclone prone area, but international NGO and or international media they are opposing that decision. So
Hmm.
actually, I want to know from the point of refugee international law, uh,
Hmm.
how it suits that. Can Bangladesh do this or not?
It's a very, very controversial question. Controversial in the sense, if you study in entirety the mandate of international refugee law, obligations under international human rights law, and application of international law, then you will find, my dear friend, that the action of government of Bangladesh contravenes some of the important state obligations. It is one of the prerequisites that the voluntary repatriation as a solution to refugee problem is very, very important. It is equally important if the government is going to resettle them in a third country, and in this case, as per your question, it is an island which is cyclone prone. And there is a lurking danger of the climate change. And there is every possibility that the years ahead, this particular island may not survive its existence. It is likely to be submerged, it is likely to be capsized. Therefore, before any kind of a resettlement, the voluntary character of return of refugees, repatriation of refugees, resettlement of refugees becomes very, very important. So who is going to ensure the voluntary character of their remigration or relocation from Bangladesh to this island? What kind of a criteria has been there? Who are the agencies which are involved? Whether the coordination has been done with that of the UNHCR on the part of the government of Bangladesh. So there are a number of technical questions, procedural questions, and humanitarian questions. As per my understanding, as a student of international refugee law, I don't see any of these questions have been addressed by the government of Bangladesh. Because it is not a humanitarian decision on the part of the government of Bangladesh, rather it is a political, logistical, and infrastructural decision. Because the entire logistical support as well as the infrastructural support that was extended by the government of Bangladesh to these Rohingya refugees is tottering under the weight of refugees. And therefore, to address such kind of tricky situations, there is a need to have a comprehensive international political understanding as well as the political support, which is known as per the global compacts and international solidarity. Whether that is reflected, and I think that is not at all reflected. Some sporadic assistance measures have been initiated by some of the NGOs and some of the governmental agencies at international level. But all-encompassing extension of support is missing. So therefore, if you analyze this entire exercise on the part of the government of Bangladesh, you will find that it is incompatible with that of international mandate. Further, we can develop, and I will definitely argue this particular case when we are going to visit again this particular case, as you have pointed out in the form of a question in the week ahead, and that is an exclusive week which was exclusively dedicated to the South Asian response to refugee crisis. Thank you.
Thank you, sir.
Now, I take you to the definition aspect. We have, as of now, deliberated various fragments, ingredients, specialized compartmentalization of this particular article, that is Article 1, that has presented a definition who is a refugee, or the refugee definition. In the form of understandings, we have been deliberating, and today I am going to share the last understanding or the last fragment of the definition. And at the same time, cumulatively, we are going to discuss another important dimensions of refugeehood, as well as I would also be discussing another important engagement, and that is exclusively devoted to persecution. What exactly the paradigms of persecution, narratives of persecution, and what has been the response of the governmental agencies as well as the governments when we are deliberating this idea of persecution. So my another important understanding, and there is every possibility you may develop further what you call nomenclatures of these understandings. I call them these fragments of the definition understandings. There, I am taking another important fragment from the definition of refugee, and that is within inverted commas is outside the country of his nationality. How should we visit this particular fragment of the definition? Technically speaking, my dear friends, someone who fits every stipulation but is still in their home country is called an internally displaced persons rather than a refugee. But in this particular case, a person who is likely to be addressed, who is likely to be viewed, finds himself or herself outside the country of his or her nationality. So this is a very, very effective nomenclature. It's a very effective fragment of this definition. It means crossing of an international borders becomes relevant. If we want to invoke the application of the definition that has been provided in 1951 UN Convention relating to the status of refugees, then it is very, very important that a person who is making such kind of a claims of relief, restoration of his rights, her rights in the country of reception, in the country of destination, in the country of refugee hosting or hosting country, then crossing of an international border becomes very, very relevant for the application of this definition, because a person who is claiming refugee status must be outside the country or outside the country of origin. Then there is a merit in the case. There is a room, some kind of an avenue arises whereunder a refugee or an asylum seeker can seek any kind of a relief. But there is another important fragment, that is the subsequent fragment, and that fragment is known as is unable or owing to such fear unwilling to return to their country of origin. So there may be circumstances. If you take into account cumulatively all these ingredients or fragments of refugee definition, then you will realize that a person in certain specific situations finds himself or herself not in a position to return their country of origin because of these circumstances. And the circumstances are the 5 important grounds which I have submitted on the last occasion. And then it is equally important to be recognized as a refugee under the Refugee Convention, my dear friends. An asylum seeker would have to show that the above or whatever the conditions I have deliberated apply to them. They are relevant conditions. They are making a case out of these conditions, and it is equally applicable. These conditions are applicable in their cases. Therefore, it becomes very, very important crossing an international border, or having a position where under the guys and dolls who are considered to be the refugees or likely to be considered as refugees find themselves unable to return to their country of origin. Then there are certain important questions which are equally important, like the questions relating to nationality, questions relating to the dual or multiple nationality, and there are questions relating to the political opinion. So these questions must be addressed within the architecture, within the understanding of this definition, or in other words, we can put it like this, that the nationality has to be understood under international refugee law. And when we are, talking of nationality, then there is another important ancillary question: the membership of an ethnic or linguistic group, then the coexistence within the boundaries of a state or two states or more, what you call, national, ethnic, or linguistic groups may create situations of conflict and also situations of persecutions or danger of persecution. So we have to take into account when we are deliberating the idea of nationality on these, grounds. Nationality under international law is having another, flavor of understanding when we are going to discuss idea of nationality under international refugee law. We have to be very specific. Specific in the sense, my dear friends, whether there has been some conflicts, what have been the grounds of these, conflicts, whether the ethnic, conflicts were there, linguistic conflicts were there, nationality, I mean, the racial, conflicts have been, there, and what exactly have been the situations of these, conflicts, what circumstances the conflicts have been germinated or gestated, and how they have, stemmed or, arising out. Then there are other important, dimensions of nationality in case of, dual nationality or multiple, what we call, nationality. It becomes very, very important that Article 1A, subclause 2, paragraph 2 of 1951 Convention, that really, demarcates and provides, and it has been placed within inverted commas, and I quote: in the case of a person who has more than one nationality, the term the country of his nationality shall mean each of the countries of which he is a national. So this clarification has been, provided under Article 1A, subclause 2, paragraph 2, as I have, submitted. Then there is another important, dimension of, political opinion. How we have been understanding political opinion. So political opinion constitutes a very, very important dimension, because what we have been, witnessing in the contemporary circumstances, that majority of the people who are fleeing their country of origin, they are fleeing their country of origin exclusively on the ground of political opinion, as I have also cited on the last occasion. A Pakistani lady who fled Pakistan because of his or her, political opinion, along with some of his, family members. So political opinion constitutes a very, very important, dimension, but it still remains to be amorphous. Not only amorphous, but it's a humongous question. What exactly are the contours and province, and who is going to determine the province of political opinion? Because if something has been said, something has been opined, something has been averred at a particular, stage, prima facie it may not seem political, but subsequently when it is, intellectually, juridically, and epistemologically rummaged, it may have some political foundations. So what exactly is the political opinion? So that is a very, very important, question, because if a refugee applicant holds opinion and these opinions are not tolerated by the authorities of his country or her country of origin or country of nationality, then in such circumstances, and generally it has been seen, these kinds of political opinions have been critical of the governmental, policies, or the national, what we call, priorities, or the methods which are generally employed in specific cases by the governmental authorities and agencies. If somebody is critical of these, dimensions of the governmental agencies, then they are generally persecuted, because intolerant attitude of the government. In such, situations, people generally take the route of, fleeing or migrating from their country of, origin or country of, nationality. In such a situation, as per the, definition, the mandate of 1951, Convention, Refugee Convention definition, political opinion is one of the most important grounds. In the same way, such opinions have come to the notice of the authorities. Definitely, they are subsequently, it has become a fashion because we have started the concept of a state from a police state. Then there was a concept of the welfare state. Then there happens to be a concept of what you call the military state. Then there has been a concept of the democratic state, a liberal state, and today we have been talking of a constitutionalized state. So different nomenclatures, different what we call categorizations of state as per the functions as well as the responses and behavior of the state, people have nomenclatured them. So in today's digital world, where we have been witnessing some kind of algorithmic humanitarianism, where the state has also taken under the garb of the democracy, rule of law, human rights, constitutionalism. But at the same time, there is another important dimension that could be attributed to the functioning of a state. Nowadays, what we have been witnessing, a minority of nation states at international level have shown some dictatorial attitudes in their functioning. They are not ready to tolerate any kind of a dissent or disagreement or any kind of a variation from their governmental policies, from their stated positions on different issues. So this is something we have been witnessing in the present circumstances, and therefore the state has become intolerant in certain particular dimensions. And therefore, the state has also created another important dimension of its functioning, and that is, and because of this very dimension, today the people and the scholars have been talking of that the state has also become a surveillance state. So immediately, whenever any opinion is expressed in the written form or in the verbal form, it is always, if it is recorded, then immediately the state authorities come to know. They take notice, it comes within the notice of the authorities, and they are, or in certain important situations, on the basis of organizational affiliation of an individual, because of his racial, caste, religious, or other forms of identities, some kind of averments are also attributed to them by the authorities to such individuals, and they are persecuted thereafter. So in such a situation, it is a whole highly comprehensive what we call narrative. Therefore, the political opinions, or suppose as I am speaking in an online class, if you take into account that an opinion of a teacher or opinion of a writer may be more manifest than those of a person in a less exposed position, because there are people who are not completely exposed, but the teachers, professors, lawyers, jurists, students, they are more exposed because they are also writers. They are also what we call contributing in their capacity as a blog writer, as a researcher, as some kind of a legal advisor. They are reducing each and everything in black and white on a piece of paper, and subsequently it is likely to be published or published. So in such a situation, my dear friends, the importance of tenacity of applicants' opinions constitute a very, very important dimension in the determination of his refugee status, in the determination of his entitlement as a refugee, in a situation, even if he is fleeing persecution, then even the international relations also play a very, very important part in these kinds of circumstances. Therefore, the measures suffered or feared by the refugee applicant have only rarely been based expressly on opinion. It has been, seen. Frequently, measures take the form of sanctions for alleged criminal acts against the ruling, what you call, power. It has been what you call, seen in certain important, situations. A refugee applicant claiming fear of, persecution because of political opinion need not show that the authorities of his country of, origin or her country of origin knew of his opinions before he left the country. It becomes immaterial. Prior information on the political views does not affect at all any kind of a, determination of political opinion. She may have concealed their political opinion and never have suffered any discrimination or persecution. But subsequently, if the refugee applicants are of the opinion that because of their prior publication of these kinds of, opinions, there is every possibility that they may attract some kind of, persecution. Even the fear of persecution is also a very, very important and relevant, what we call, element in the determination of refugee status. And further, we would also be appreciating in the very next what we call, engagement, which is going to talk of what we call, asylum. At the same time, it would also be, taking into consideration some other form of, dimensions. Mere fact, my dear friends, mere fact of refusing to avail himself or herself the protection of his or her government or nationality, or a refusal to return, may also disclose the applicant's true state of mind and give rise to fear of persecution. So this is how the fear of persecution should be understood. And there is no dearth of, such cases, because in such, circumstances, the test of well-founded fear, within inverted commas, my dear, well-founded fear would be based on an assessment of the consequences that an applicant having certain political understandings, political dispositions, political opinions, and would have to face it if he returned. Upon even return, if you invoke Article 13 of Universal Declaration of Human Rights, a right to leave one's own country and return to it subsequently, that is the right which has been, incorporated under Article 13 of the Universal Declaration of Human Rights. Then, my dear friends, even in those, circumstances, prima facie, it has been seen the governments promised all hunky-dory situations for the returnees, but after returned, they have not been given adequate treatment or range of rights which have been promised to them. Suppose, forget about this situations of returnees. There may be some other important, situations. Situations like in South Asia, the treatment with minorities or treatment to minorities in Pakistan is not up to the human rights standards. State obligations on the part of the government of Pakistan have not been adequately upheld as per the international state obligations, human rights obligations, or the human rights treaty obligations. Same has been the situation in Afghanistan, where the Sikh community has always been discriminated by the state actors, non-state actors, and non-state armed groups actors in Afghanistan. And how international media reacted and reported to these kinds of persecutory tactics of these nation states from South Asia. Government of India has received refugees from Pakistan It is good that the government of India has received refugees from Pakistan. And the government of India has also extended all kinds of supports at the time of their arrival, not written, my dear friends. They are the, Pakistani nationals, but because of their religion, because of their membership of a particular, minority or religious minority, they have been persecuted and they preferred India as their natural home. So they have been received and there is no harm in receiving them. But the story begins after their arrival. Whether the government of India, now the question arises whether the government of India has been successful, has been up to the mark after their arrival to extend all kinds of constitutional rights to them and the rights which have been promised under international refugee law. If government of India is not a party to 1951 convention relating to the status of refugees, then it is also the part and privy to a range of international human rights obligations emanating from international human rights treaties. So the situation of these refugee arrivals from Pakistan of the minority, Hindu minority community from Pakistan are not up to the mark. They are still running pillar to post to claim certain important rights which are essential: right to health, right to education, right to dignity, and other important range of rights. Intention of the government of India has been bona fide, but what kind of state authorities, what kind of an attitude is there of the state authorities, particularly the state governments, that becomes equally important in such kind of situations. So we have to see, and there is a requirement, there are some empirical studies, even from one or two students from South Asian University, they were your seniors, my dear friends, they have also conducted some empirical studies, particularly on such refugees, and they also conducted studies on Rohingya refugees who are living in the vicinity of Delhi or in the surroundings of Delhi. On many occasions, they have been removed by the state authorities, by the central authorities in India. Even in Rajasthan, in Delhi, in Aligarh, in Northeast, in Jammu region, in Kashmir, and some other parts of the country. I mean, country means India in this discussion. Refugees have voiced their concerns, and I am particularly talking of non-Muslim refugees. Though Rohingyas are Muslim refugees, but refugee as a whole, what kind of rights have been there? The most important refugee group in India is Tibetan refugees. They are getting all kinds of rights, all kinds of facilities, and their stay in India has also been very comfortable. And the second category, who is more what you call comfortable than rest of the groups of refugees, is Afghan refugees. I don't know Afghan. I mean, my friends from Afghanistan and Pakistan and Afghan refugees in Pakistan, they are in a better position to evaluate my statement as well as to share their own lived experiences. So we would also be coming to, in that very week, we would attend all these dimensions. At this stage, what is important is the well-founded fear, because well-founded fear is a very, very important expression, and it is also having a very comprehensive application. Suppose I can give you some other important examples. There is another important class of refugees which is known as refugees surplus. And the word surplus should be written in inverted commas, SUR, space, PLACE, place, inverted commas close, surplace. Refugee surplace is that category of refugees, my dear friends, or there may be a situation, a person who was not a refugee when he left his or her country of origin or country of nationality, but who becomes a refugee at a later date is called a refugee surplace. Due to circumstances, my dear friends, arising, I mean, these circumstances emanating in his or her country of origin during his absence. Suppose a person from Bangladesh, when he started and left his country of origin, that is Bangladesh, with valid documents, with requisite what he call paperwork, and he leaves his country of origin for United States of America for some reasons. It may be a business reason, it may be some kind of a conference related reason, it may be academic, it may be what he calls some technological or scientific reason. He leaves, but in his absence there are some changes, radical changes, dramatic changes or drastic changes take place in his country of origin, I mean in Bangladesh. As a result of, there may be a situation, as a result of his own actions when the circumstances were normal, such as associating with refugees already recognized in Bangladesh, or expressing his political opinion or political views in his country of residence, or by virtue of his membership of a particular social group, or he because of his association of a particular NGO or a political organizations which does not subscribe to the views of the incumbent government or the governmental agencies. So because of these reasons, and because of the change, fundamental change in the circumstances back at home in Bangladesh, he may have a fear of persecution because of his past actions. So in such a situation, immediately in the new territory where he happens to be in a given situation, he may also apply for refugee status, and such kind of refugees are known as refugees surplus. So number of I mean situations may be there which make people refugees. So these circumstances must also be addressed. Now, if you further deliberate how a political offender is likely to be considered as a refugee, and what are the prerequisites, what exactly are the requirements to consider such kind of political offenders as refugees. What could be the possible elements? What kind of a criteria should be there, and what should be taken into consideration by the governmental authorities? Governmental authorities, as well as the mandate with which United Nations High Commissioner for Refugees have been empowered to determine the refugee status. Then to me, the number one point that comes to my mind is the overall personality of an applicant should be considered. Personality not in terms of his chiseled face or some kind of a facial contortions. I am not talking of these. These are I mean, these kinds of attributions would land me in an act which is violative of international law, and that is popularly nowadays known as racism. So it is not a question of racism, rather the personality of the applicant means the political personality of an applicant, which is based on his political opinion. What kind of a political opinion that particular fellow has expressed. Then we have to consider as a RSD official, so the refugee status determination personnel or official, it shall also be the responsibility and duty of such kind of officials. They should take into account what exactly has been the intent behind a political opinion or an act that has been committed, a political act I am talking of. It may be a criminal act on the part of the government understanding, but on the part of the applicant's understanding, it is a political act. Then we have to take into account as a refugee official how a person should be treated. Then we have to take into account the nature of act that has been committed. Thereafter, what kind of a legal consequences, penal consequences, or what may be the criminal inferential consequence is there that emanate or arise out of such kind of actions which have been construed by the incumbent government as a criminal act. It means what we have to undertake is how we are going to appreciate as a refugee official is nature of prosecution along with the motives with which it has been committed. So motives of prosecution. So here again, we have to undertake, and I should not attribute and I should not give you vivid and clear-cut examples from the recent developments in South Asia. Because a movement is going on. And opposition is going on. People in Pakistan have constituted an alliance of the political parties against the incumbent government. In Afghanistan, there is no political consensus. Even in Bangladesh, there are political oppositions, and the governments of this region have become highly intolerant to any kind of opposition. Even in Europe, you will also find that the governments have become of late very intolerant. Even in United States of America, what kind of an intolerance the journal masses, particularly the political opposition, has confronted with during the Trump administration. And how government of Australia has been behaving in case of refugee influxes. And notable examples that should be taken, so far the refugee influxes are concerned, then we should not forget what kind of a behavior has been there on the part of Austria, government of Austria, opposition in Germany, and what kind of a political intolerance we have been witnessing in Russian Federation. Navalny's Navalny's decision is a case in point. That should not be what we call though the refugee issues are not involved, but the political opinion is involved. So how it has become difficult to express any political opinion in the contemporary circumstances. And in majority of the situations, you will find that it is it has become the most notable and central argument on the part of refugee influxes, refugee exoduses, that because of their political opinion, they did not have any option but to leave their country of origin. So we have to take into account not only of the nature of prosecution along with the motives, but at the same time we have to understand what exactly has been the nature of law on which the prosecution is based. Whether the law is sufficient to take into account, because it has been seen, and the judicial systems in majority of the nation states should be appreciated, that after languishing in jail many individuals, because of their political opinion, they have been, acquitted. So how these acquittals should be what we call, seen and appreciated. Then, because if we take into account all these, elements, then these elements, my dear friends, may show that the person concerned or the refugees concerned has a fear of, persecution, and not merely a fear of, prosecution and punishment within the, law, particularly an act which they have, committed. So this anomaly should also be taken into consideration. Then let me clarify, there may be, certain questions in your mind, and these questions are also, there in my mind, and let me answer them. The question is, what should be the understanding of particular social group, which I call in abbreviation PSG? So what exactly and how should we appreciate and what should be the understanding of particular, social group? So what exactly are the dimensions? What is the face of this particular, social group? What should be the pervading line of argument? Should there be any kind of a unity in this particular, social group? Whether the social group is based on religion, whether it is based on caste, whether it is based on ethnicity, whether it is based on political opinion, whether it is based on some kind of a, philosophy. So these are the, possible questions relating to the dimensions as well as the, foundations of a particular, social group within inverted commas. My first clarification is that a social group is united by something else other than its persecution. It should be construed as a social group, as a particular, social group. Second important explanation from my side would be that the membership of particular social group is not necessarily voluntary. There should not be any kind of a documentation that somebody belonging to a particular, social group, and therefore he has to show some kind of a, document. That is not at all required. Another important explanation could be, my dear friends, that a common activity or organization is not at all necessary for a person to belong to a particular social group. It is not at all required. Another explanation which I perceive as immutable characteristics. Let me put it like this: immutable characteristics approach, or you may call it distinction driven characteristics approach, is sufficient to demarcate, to locate a person who may be a member of a particular social group. At the same time, we should also take into account the size of the group, of a particular, social group. What is the size of this particular, group? So these are some of the important, clarifications that should also be taken into consideration while granting refugee status to an individual exclusively based on the membership of a particular, social group. Because there has to be a nexus. When we are, talking of well-founded fear of being persecuted, for reasons of race, religion, nationality, membership of a particular social group, or political opinion. Then, in such a situation, we should try to establish a interwoven relationship, a relationship that creates a nexus that there is a well-founded fear, there are reasons of race, and other rest of the four important elements which have been incorporated and encapsulated in the definition of refugee in the Refugee Convention. And at the same time, a person should be outside his or her country of origin. It means he is not in a position to avail the protection of his country of nationality. But there are situations, not exactly situation, I should not use the word situation, rather I should use the word dilemma. There happens to be a dilemma, and the dilemma is, because the first dilemma is that what about those people who are not in a position to cross an international border, who are generally known as the internally displaced persons? Then there is also a debate, and that debate has created a dilemma. And debate is, that gyrates around protection versus intervention. And this intervention has created a lot of problems for international community. Because international refugee law takes into account the idea of protection. And it is not only the idea of protection, but it is at the same time, it is also qualified by a prefix as an adjective, which is known as international, and it becomes international protection. So in such a situation, it is a debate around international protection versus intervention. And that is why that ultimately necessitated, my dear friends, to have these two global compacts. It means international solidarity with the refugee hosting country. That particular element has become the part of global compact on refugees. Therefore, to a very great extent, this dilemma is likely to be diluted in the years ahead. Because when we are talking of intervention, then a very important consideration is there in the minds of geopolitical entities. And that important consideration is nothing but sovereignty. So sovereignty plays a very, very important part when we are talking of intervention or international intervention for the protection, which is generally directed at the protection or international protection of refugees. Because in this context, question of nationality also plays a very, very important role. And the question of nationality always refers to citizenship under international refugee law. And it is distinct from the concept of statelessness or stateless persons. Because one of the most important functions, along with many other important functions of international refugee law, is also to provide surrogate protection. We would also be discussing the idea of protection under 1 week, that is week 10, where we are going to study the idea of temporary protection. So in that particular week, we are going to deliberate further the idea of surrogate protection. Because if you take into account the words like in one of the fragments of the definition, again, I am taking you back. and that is one of the important fragments which we have already deliberated, and that is unable owing to such fear. That is the last important two fragments of the definition of refugee, and that is unwilling to avail himself or herself of the protection of that very country or the country of his nationality or origin. So in such a situation, surrogate protections becomes very, very important, because there is every possibility of a civil war. There may be circumstances of international armed conflict, and that really make unable to avail the protection of his or her country of origin, or there may be unwilling means fear, because of some kind of a credible fear. A person, there may be a possibility, is not ready to go back to his or her country of origin and avail the protection of his or her nationality. Therefore, in such circumstances, my dear friends, we require to remove, and to a very great extent, these two global compacts of 2018 have really come for the rescue of the entire institution of refugeehood and institutionalized, though it is non-binding, it is not legally binding, compacts, but at least a political understanding has been, corroborated, that has been established, and ultimately the nation states are going to be in a position to revisit or to visit entire refugeehood de novo, and they would be in a better position to attend the political implications and the political questions which are involved and generally arise out of international intervention in a geopolitical entity, and that should also be considered as an added advantage for the protection of refugees in a given situation. Then there is another important engagement, and that is relating to international law instruments. When we are talking of from our deliberations, it is our collective, well established understanding, my dear friends, that in the current scenario of refugee protection, and you would be sharing my understanding, and that is why I have included all of you in this particular understanding, then we do not have a single definition of refugee that is relevant, suitable, and germane to all circumstances, to all kinds of purposes. We do not have any definition of such a character. When associated with humanitarian aims, the connotation of term differs from that is used in international agreements, since the human rights aspects of the refugee problem are clearly distinct from the opinion of a particular refugee, or the question of a particular refugee protection, or from the point of view of determining the refugee status in a particular given circumstance. And therefore, I am of the view, my dear friends, that all refugees have in common certain important characteristics. The very first characteristics that comes to my mind is, without any kind of a distinction, my dear friends, all the refugees are uprooted. They are homeless, and they are deprived of national, protection. They do not enjoy any sort of, status, a national status or nationality status, citizenship status, because this status comes with a lot of what we call, rights. At the same time, my dear friends, it should not be forgotten that refugees are involuntary migrants. They are the victims of politics at home. They are the victims of conflicts and violence and war. And nowadays, what we have been witnessing the emergence of a new class of refugees, which is known as the climate refugees, because they are the victims of natural catastrophe. However, every refugee is naturally a migrant, but not every migrant is a refugee. So we have to draw a distinction: who is a refugee and who is a migrant. My dear friends, a migrant is one who leaves his residence due to economic reasons in order to settle elsewhere. It may be his or her, own country, or it may also be another, country. So far, the refugee movement is concerned, a refugee movement results when the tensions leading to migration are so acute that what at first seemed to be a voluntary movement becomes virtually compulsory movement. They are compelled to leave their country of, origin. So in such a situation, the social, crisis brought by the de facto immigration of so many refugees convinced governments that their laws would have to recognize the reality of the forced international movements of people as political and other, disruptions would inevitably induce involuntary migration. Policies of the selecting immigrants on the basis of national advantage alone were, obliged to yield in such, circumstances. The nation concerned had no practical powers to control the flow of humanity in some specific instances, in some specific situations, as we have, witnessed in the Syrian refugee migration towards Germany and towards, Hungary and rest of the, European nation states, where a quota system has also brought in by the European nation states. If you want to further study along with myself, then we should not forget. And the week 7, we would be deliberating this particular, treaty, that is EU-Turkey treaty, and what has been the contours of the treaty and to what extent it has been able to address the Syrian refugee crisis in Turkey as well as in the rest of the European nation states, and to what extent the European Union has been able to tide over the current crisis. Because there are, certain important political allegations against this, treaty. It is being alleged by some of the, domestic opposition leader in Turkey as well as in Syria that Turkey is creating refugee-like situations in Syria. And this particular deal in the form of a treaty that is popularly known as the EU-Turkey treaty, it is a result of the political chicanery engineered by President Erdogan of Turkey. Because he wants a lot of money and he is basically an extortionist, treaty. And it is heavily tilted in the interest of, Turkey in the name of hosting Syrian refugees. It is minting money. So this kind of a allegation is there. So in this particular backdrop, we have to study the entire EU acquis on international refugee implications. I mean, European Union law we have to study to a limited extent when we are going to discuss the reception of refugees, the protection of refugees at a regional level. So what exactly the European mechanism is there for the reception of these refugees that we have to undertake. Now, the question who is a refugee, we tried to understand in the light of this definition, and we would also what you call try to further understand in the next week who is a refugee under the law of asylum. We are also going to further understand who is a refugee under RSD mechanism, and that is the refugee status determination mechanism. But before we proceed further, it becomes equally important that there are certain important perspectives. And some of the perspectives I have already shared with you when we were talking of the anthropological definitions of refugees, the sociological definitions of refugees. But in the realm of law, we have to undertake and we have to appreciate what exactly is the semasiological perspectives on refugees that has also created a lot of dilemmatic and ambivalent situations in understanding the contours of this particular definition. Then we have to undertake certain understandings, and these understandings I have also incorporated in my PhD thesis, where I have also deliberated some of the important aspects, but the circumstances have changed from the time when I have researched as a PhD scholar who is a refugee and how a person who is considered to be a refugee is going to be, and what kind of a status in present circumstances we find and attribute to this particular class of people who are on the move. Then if you take into account, we have basically undertake pre-1951 understandings of refugees, which I have also deliberated with all of you in the very first week when we were deliberating. And he started our understandings of understanding the international refugee migration since Treaty of Westphalia, Treaty of Peace, and how other important religion-driven understandings has also been there. So at this stage, it becomes very, very important to understand the pre-1951 UN Convention relating to the status of refugees understandings. We have to further understand the juridical perspective of refugees. We have to undertake another important perspective, which is popularly known as the social perspective of refugees. We have to undertake another important understanding, and that is the international perspective of refugees, because these understandings are important, and therefore it is our abandoned duty to understand all these what we call dimensions provided under these perspectives, because each and every perspective is shaping the understandings of the refugee determination officials, including the individualist, what we call perspective, international perspective, juridical perspective, the social perspectives. So, and if you take into account what kind of a perspective has been there, and that is the pre-1951 understanding. If you conduct an intellectual autopsy, my dear friends, and provide an analysis on the basis of this intellectual autopsy of international refugee regimes, particularly concluded between 1920 and 1950, we come across that this particular period of refugee regimes which have been concluded divulges trichotomical perspectives with regard to refugee definition. Each of these perspectives convey different kind of categorizations, as I have just mentioned before you. And these categorizations were dominant during a part of the initial decades of the development and evolution of international refugee law. Let us begin with what exactly could be the juridical perspective. Juridical perspective, my dear friends, gestates the initial series of international refugee definitions. And these definitions were primarily concerned with the juridical phenomenon of refugeehood, which I called refugeeism. The notion that the refugee is a member of a group as a notion, as a concept. And refugee, by virtue of his being part of this kind of a trichotomical understanding, does not have any kind of a freedom, particularly the freedom of international movement, because the members of this juridical phenomenon understanding, when we are appreciating refugees under this juridical phenomenon understanding, they have been deprived of the formal national protection of their governments. That is the basic understanding as a lawyer. This is a basic reception of this understanding in the juridical proclivity of all the individuals who are in the field of higher education or legal higher education. The purpose of refugee status, my dear friends, conceived in juridical terminology, is to facilitate the international movement of persons who find themselves abroad and unable to resettle because no nation is prepared to assume responsibility for them. These initial and first definitions of refugees were formalized in response to the international legal dilemma that was, my dear friends, caused by the denial of the state protection. That should be the phenomena of juridical understanding. Because there happens to be a withdrawal. Withdrawal of what? Withdrawal of de jure protection by a state. Whether by way of dematerialization or the withholding of the diplomatic facilities, such as travel documents, consular representation, consular access, and that ultimately and cumulatively speaking results in a malfunction in the international legal system. And in such a situation, it is basically a deprivation of national protection. At the same time, prior to the later half of the 20th century, my dear friends, or prior to the later part of the century that is exclusively devoted to international law, did not recognize individuals in the stricto sensu as a subject of international law or international rights and obligations. Determination of responsibilities, my dear friends, or the international place have felt to the sovereign state whose protection they have been enjoying or they enjoyed the protection of their national governments was not available to them. When the bond of protection between citizen and state was severed, no international entity could be held accountable for the individual's actions. Therefore, the result was that the states were reluctant to admit to their territory individuals who were not the legal responsibility of another country. The most fundamental form of de jure withdrawal of state protection is, of course, denaturalization. And we understand it because how to get citizenship or nationality, this is something we have already studied in our international law classes. But it was the general policy of the League of Nations. If you turn back the pages of the legal history at international legal history of international law, the institutional framework of protection under international law, then it was the general policy of these kinds of international organizations, particularly of the League of Nations, to extend protection to groups of persons whose nationality had been involuntarily withdrawn by their states of nationalities. League of Nations recognized that persons who could not obtain valid passports and other important what we call travel documents were entitled to international protection. It has been recognized. Both, migrants and refugees were bestowed upon League of Nations, and League of Nations recognized them, and League of Nations came out and extended identity certificates with the contracting states. And the contracting states have also become agreed to recognize as the operational counterpart of passports until the durable solutions were found for the voluntary repatriation, resettlement, and reintegration of these refugees. An idea of durable solutions came into existence. If you take into account, particularly the definition aspect, definition of this particular period contained a criteria of ethnic or territorial origin coupled with the stipulation that the applicant, refugee applicant, not enjoys the de jure national protection. So it was recognized juridically, my dear friends. It is one of the most important developments if you take into account the actions, how the refugee status evolved, how the refugee status determination developed under the charter of the League of Nations, so during the regime of League of Nations, and how the national protection that was appreciated under the auspices of the charter of the League of Nations. Only persons applying from outside their country of origin during this particular period of League of Nations, my dear friends, were eligible for refugee recognition, consistent with the motion of the refugee, concept of refugee, and the notion of refugee as an international anomaly. How? While the unprotected individual remained within the boundaries of his or her home state, and there was no question of another country being confronted with a person outside the bounds of international accountability, and accordingly, my dear friends, no need to include her within the scope of the League of Nations protection. So in such a situations, an exceptional clause was also created. So it was basically this particular the relevance of the juridical perspective in this particular situation. We find that during the charter of the League of Nations, It has been the consistent policy since the conclusion of the Treaty of Westphalia in 1648 that the travel documents or the valid what we call visa have never been the bone of contention of the refugee regimes. Rather, this has been considered as some kind of a natural development, because it is not at all expected from the refugees who are running in a huff and fleeing persecution to produce all such kind of identity documents. They were not at all in a position, because it does not appeal to reason, that it should be expected. Even legal mind does not accept that a refugee who is claiming a refugee status or knocking the doors of another country, he must have all these kinds of documents. So it is not at all expected from them. And therefore, these juridical limitations, juridical evaluation of their relocation and mobility has been appreciated. Now, if you take into account another important perspective, and that is a perspective which is known as the social perspective. So far the social perspective is concerned, it was an approach, you may call it a social approach. And this approach, my dear friends, was dominant between, or rather this approach has always been the most conspicuous approach in a particular time frame, that it starts from 1935 and goes up to 1939. In these 5 or 4 years, we witness that the social approach to refugees definition has been dominant. Refugee or the refugees defined from the social perspective are the helpless casualties of broad-based social and political occurrences which separate them from their home society. Assistance in migration is generally afforded to refugees not from the juridical perspective with a view to correcting an anomaly in the international legal system, but rather in order to ensure the safety and well-being of refugees. For example, if you take into account, my dear friends, that we have witnessed, I'm sorry, I'm having a little bit problem here. If you take into account, and that is why I stood up. So let me, my face should be visible to you. If you take into account the refugee migration, particularly of refugees from Syria, that is started in the month of March way back in the year 2011, we have been witnessing this Syrian refugee crisis. Then the idea of which has been institutionalized by many scholars in the current scenario, and this institutionalization is known as voluntarism. During this particular time frame which I have just mentioned, that it starts from 1935 and goes up to 1939, a 4 or 5 years time frame. In this particular time frame, my dear friends, what we have been witnessing, though this particular terminology was not available to them to attribute this particular time frame, it has been simply said as a social perspective. But primarily now it is known as the voluntary or voluntarism driven perspective. It has been institutionalized by many scholars. As I have given you an example of the Syrian refugees and the Syrian refugee crisis, then in this particular crisis, if you take into account that even in the absence of law, the first batch or the first what you call refugee exodus that took place in the month of March in 2011, and they had it after crossing the Mediterranean Sea, and they knocked the doors of Hungary. Then the border villages immediately volunteered and provided, and they what you call they rendered their services voluntarily and provided humanitarian assistance to these fleeing people or refugees from Syria. They were fleeing violence and war, and immediately lot of relief material was provided to them in their, I mean by the villagers, individual, in those villages in their individual capacity, without any intervention on the part of the governmental agencies or in the absence of a formalized mechanism. So it was basically a social perspective, which is today known as voluntarism. So we have to undertake this particular, idea into account while appreciating the idea of, perspective. But, and this idea was also, known as I have earlier, submitted, assistance in migration. But in contrast, refugee definition established between 1935 and 1939 reflects a significantly stronger orientation to respond to the social phenomenon of refugeehood or refugeeism. If you take into account the different categories, my dear friends, categories of persons eligible for international assistance, encompassed groups adversely affected by a particular social or political event, not just those united by a common status vis-a-vis the international legal system. You will also find that the essence of this actual definitional approach was to continue to assist persons without formal national legal protection, but to assist as well as the victims of social and political events which resulted in a kind of a de facto, if not de jure, of state protection. For the first time, or for most part of these agreements which generally took place as a part of the social responsibility, as a part of the social perspective, these documents which have been concluded in this particular time frame sought to protect persons caught up in the upheaval and dislocation that is exclusively, my dear friends, caused by the national socialist regimes in many nation states. Because the political regimes have also caused a lot of refugees. Suppose in this particular time frame, you will find that these were the halcyon days of the Hitler regime or the Nazi regime in Germany. Because of the indoctrination of this ideology, Nazi ideology, many refugees have been generated, dislocated, displaced, and compelled to flee their country of origin, to leave their natural habitation, and they took refuge even in France, in the neighboring areas. And even during this particular interwar period that ultimately concluded in 1945, Holocaust took place. So if you take into account this kind of a perspective, what kind of a upheaval, political upheavals were there, even these, perspectives were also, caused by the political circumstances. So therefore, the social perspective emanates from a multiplicity of, circumstances. Social perspectives traces or trace its, origins, genesis, and etiology from a variety of, circumstances, from a compendium of hostile situations, and that really generates some kind of a social belongingness and social feelings without any kind of a, institutionalization, without any kind of a formalization of norms, institutionalization of laws and mechanisms, but it is basically a concept of voluntarism that comes out by virtue of our being the members of the human family. Therefore, in this particular, time frame, the substantive scope of the definition during this particular period of history of international refugee law, refugee was, defined by an en bloc reference to journal and situation specific categories of persons affected by the adverse social or political phenomenon. And therefore, this intersectionality of human displacement was not at the forefront. Rather, everybody was, addressed as refugees. Second phase in the evolution of international refugee definition, my dear friend, was characterized by a move away from the earlier preoccupations with the loss of de jure state protection. The new definition was designed to encompass the victims of broad-based social and political hierarchy, the political upheaval, whether or these were, problems of international legal status or not, irrespective of their, legal implications, the new definition was coined to incorporate, to address the victims of broad-based social and political, what you call, pandemonium. Here lies another important, what you call, perspective, and that is popularly known as the individualist perspective. In this particular, perspective, you may also have some additional, perspectives, because I'm also having some other important, perspectives, which also, define and impacted, definition. And I also, came out many more such what you call, perspectives. I don't know whether you are going to like them or not, but that has also become the part of my, understanding, which I have, presented almost, 2 decades ago when I was, writing the draft of my, thesis. So, individual perspective. The development of international refugee definition under individualist perspective, my dear friends, is distinguished by its move away from concern with the group disenfranchisement, whether the de jure or de facto, or towards a consideration of relationship between a particular individual and his state. This is how we should try to understand individualist perspective. The essential characteristics of refugee came to be the existence of the fundamental incompatibility, my dear friends, between claimant and his government. Refugees were defined as per the individualist, understanding, individualist perspective, in primarily individualistic terms between 1933 and that goes up to 1950. So this entire period of, of almost or more than 37 years, or rather I should say almost, 40 years, because prior to 1933, If you recall what I have, submitted in my, submissions when we were, deliberating, the evolution of international refugee protection after the conclusion of the Treaty of Westphalia, then in this particular period of time, between 1933 up to 1950 or 51, when the current what we call, refugee convention was concluded. So it has been, felt, it has been, visited that a refugee by individualist standards is a person in search of an escape from perceived injustice in his her state of origin. A refugee distrusts, my dear friends, the authorities who have rendered continued residence in his home state either impossible or intolerable, and desires the opportunity to build a new home life abroad, or a new home abroad, or in another country. Refugee status, glanced from this particular individualist perspective, is a means of facilitating international movement for those in search of personal liberty and personal freedom. So personal life, right to life and personal liberty has been acknowledged, and it has been considered as one of the most important contribution of the individualist perspective during this particular period. And that is why it is one of the most important allegations against the current definition of refugee, which is considered and regarded as the international definition of the term refugee. And it is a allegation that comes from the Afro-Asian understanding of the entire international refugee law. And this is the most dominant dislike of this particular definition. Though I may be wrong in using the word dislike, but there has always been a lot of opposition by the 12 first understanding and the 12 second understanding. And we are currently having the second generations of dwellers. They have also started what they have opined in as a part of what we call of the 12 first generations or 12 first generations of Afro-Asian legal thinkers, or the juridical approaches which they have opined towards understanding international law, because they have started understanding international law from below. So it is a global south what we call opposition to this individualist perspective, where we find the dominant nature of civil and political rights. And here also, my dear friends, during this particular period of international law history, when we are basically talking of the evolution and development of international refugee law, we come across that in this particular period that it starts from 1933 and goes up to 1950, we find the dominant approach is an individualist approach, and it has ultimately institutionally individualized the refugee understanding, and that is not at all that has never been what we call receptible. Rather, it has been taken in the subsequent years in 69, when Africa continent came out with some of the most important what we call instruments for the protection of refugees, and it is nothing but OAU convention relating to the problems of refugees, or convention specifically governing the problems of refugees in Africa, and that came out. And this is how under Article 3 of the OAU charters, definition of refugees in Africa complemented this individualized definition of 1951, and they have provided a collectivized definition of refugees in this particular convention. So that has been the result of individualist perspective, because individualist attitude initially cast a shadow, my dear friends, on the determination procedure regarding decision as to whether or not a person was a refugee, because Afro-Asian or global South nation states perceived refugees a collective problem, a group problem, a communitarian problem. But Europeans have, or Eurocentric approach, visited this particular issue within the lenses of individualism. So it is the individualist perceived that was very dear to the hearts of what we call of the European thinkers, and particularly the political entities, geopolitical entities, and they have given primacy to the individual rights while appreciating even the contours of definition. But on the other hand, the global South nation states were of the view that it is not an individual problem. A refugee is not an individual, rather a collective appreciation, a communitarian approach is required in understanding. And therefore, as per the individualist perspective, my dear friends, the status as a refugee was no longer determined exclusively on the basis of political and social categorizations. Rather, the accords of the immediate post-war era prescribed an examination of the merits of each applicant's case. Even in situations of refugee exodus, even in situations of refugee influx, the authorities contemplated the idea, even in the post-1945 era, the nation states were of the view, particularly under the auspices of the United Nations organizations and the temporary arrangements which have been, created under the auspices of the United Nations, like what we call, International Refugee Organization for Russian refugees, and some other important, agencies under the auspices of the United Nations organizations for, other kind of, Austro-Hungarian, refugees, and other, sections of, refugees within the Europe. They have basically, talked of with the lenses of individualism. So the collectivity element was, missing. And therefore, or rather I should say, the steps to a more personal conception of refugees or refugeehood altered the substantive notion of the refugeehood. Essence of refugee status, my dear friends, therefore, in these circumstances, came to be sustained between the individual refugee applicants' personal characteristics and convictions and the tenets of the political system in his country of origin, that have basically become the dominant what you call criteria to grant any kind of a refugee status to an individual, because international community did not universally embrace the subjective concept of a refugee. They found objectivity in the determination of an individual refugee status. They were not at all worried about the collectivity of refugees. The sufferings, pains, deprivations, dehumanizations, demonizations of the human existence on the collective footing were, or rather, these were not their priorities. Rather, it was the individual concerns, individual pains, which ultimately guided their entire what we call RSD procedure, RSD mechanism, that is the refugee status determination procedure, and therefore it was contested disastrously that, and in futility as well, I should say, that refugee who had sustained no political or personal prejudices and predilections ought not to be protected as refugees under the auspices of the international community as a whole, but should instead seek the assistance of those individual states or the collectivity of states that are sympathetic to their political preferences, ideological orientations, and peerage pursuits. So it has been cast upon that if we are sympathetic to a particular group of people, that it should be the responsibility of that particular sympathetic nation state to come out with humanitarian assistance for them. So it has been contested on number of what we call occasions when we have been talking of an individualist perspective. Therefore, this particular time frame of the evolution of the international refugee law, it has witnessed, my dear friends, the tremendous individualization of refugee law, and that was witnessed in this particular period alone. which was ultimately dictated by the voting strength and influence of the Western Alliance. So this Western Alliance should be what we call, it was a mechanical and technocratic what we call, alliance that ultimately dictated, even to a very great extent, even the industrial revolutions have also further enlarged the applications of this individual rights, philosophy. Ultimately, my dear friends, this lead to a movement away from a focus or group de jure or de facto disenfranchisement, my dear friends, and towards a personalized evaluation of incompatibility between state of origin and refugee claimed or refugee claimants in search of a personal freedom and liberty. And this initiative, my dear friends, during this particular period of time, which is that has been categorized as individualist perspective, define refugee concept in a manner consistent with the ideology of those powerful states, set the stage for the development of contemporary international law. But we have witnessed some kind of a revisitation of these global northern nation states perspectives, which were primarily based on individualism. We have witnessed a sea change in their attitude, and that was witnessed in the conclusion of the two global compacts in 2018. Thank you very much. I will complete tomorrow these particular understandings along with some other important perspectives as well. Only 2 and 3 perspectives still remains to be deliberated, so we would be deliberating them tomorrow. So thank you very much, my dear friends, for your valuable time and your cooperation, and I hope you will continue to provide me your support and this kind of coordination. But before I leave, let me make a request to all of you that please email me your term paper topics latest by 15th of March. I will also email you, and very positively by tomorrow I will also email entire material, because I was busy preparing the requisite material for those deliberations which we have already completed, and whatever the deliberations I have submitted in these online classes, the requisite articles and other important ancillary material which I intend to share with all of you by tomorrow. Very positively I will share, but I request all of you that please start writing your term papers, and it is my humble submission to all of you, please do share your term paper topics. Thank you very much.
Thank you, sir.
You're welcome. You're welcome. Thanks a lot.
Thank you, sir.
Good. Thanks a lot.